These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
We've had some questions regarding, there's some of you that are in the middle of some situations that might consider a process right now. It's important that you understand what you're doing on this. So before you just go jump off the cliff and try something that could cause you great difficulties, let me admonish you to consider getting a little bit better understanding of this game called contracts. Because that's exactly what you're doing. You're in the middle of contracts. Tonight we're going to do a little bit of contracting. I talk to a lot of my students. This whole game, from my viewpoint, is merely being nothing but, nothing more than, only contracting. That's all it is. And what's a contract? What constitutes a contract? If it is as I contend, then the importance of understanding contracts is critical. And so I recommend that you get a book, something like Brian Blum, Contracts, Examples and Explanations. There's Restatement Second, Williston on Contracts, Corbin on Contracts. Get yourself some contract material or books and get an understanding of what a contract is. Because it's not overly complicated, but there are some basics that are very, very important from my point of view that you get internalized. How does public policy view contracting? What does a judge think when he's trying to get you into a contract? What is a contract? How do they work? What constitutes a contract or an agreement? And I'll tell you a couple of stories and a few things, but that will help you orient yourself a little bit in this world of contracting. There's so much misinformation out there regarding a contract. We need a meeting of the minds, that kind of thing. But it kind of boils down to two fundamental basics from public policy's viewpoint. One is what's termed the assent policy. It's important that it be volitional, voluntary, that you enter into a contract. Seems fair enough, right? And then there's a thing called expectations or protecting reliance and the security of transactions. That's your two major issues that are going to be dealing with in this thing called contracting. Tonight we're going to be doing some contracting. What did Julio do with the Attorney General of Illinois? He sent in an offer and he received a call. Brandon will tell you he's very good at it. Contracts are dynamic and fluid. They move. And how do they move? They move because you make them move. And Jack and I and Brandon tonight, we're going to play a little bit of being in court and what constitutes a contract. But I'll read you a little excerpt or two from contracting. And this is critical because a lot of people are under the misinformation that contract requires a meeting of the minds. What constitutes a contract? Although agreement between the parties is essential to the creation of contract, the question of what constitutes legally sufficient agreement can be difficult. The question is discussed in detail later. Law does not demand an inquiry into the minds of the parties to decide whether they had formed an actual intent to contract. Such an investigation into the actual thoughts and understanding of a party, called subjective intent. We have objective and subjective. Subjective is of the mind, objective is outside of the mind, objects. If I tell him, and I'm an officer, get against that wall, and he does it, do we have a meeting of the minds? She says no. Yes or no?
If nothing else, do we not have assent by conduct?
We have a meeting of the minds. He only went over there because he thought about it and did it. So obviously we had a meeting of the minds. In other words, I can't hear what he's saying. I don't want to do this. I'm reserving my rights. And well, I don't got to worry about it. I already know what he's doing. The officers say, that's fine, no problem, your rights are reserved. Now give me your fingerprint. I'm doing this under duress. No problem, just give me your prints. You're going to have some interesting times what constitutes a contract and who's delivering the contract. Now, called subjective intent would not adequately protect the other party's reasonable reliance on apparent intent as portrayed by words and conduct. I don't want to hear what he's thinking. I don't want to hear what his mouth is. I just know what he's doing. And that's what the judge is going to do when you come in. And there's some other things to it. But by words and conduct. Also because the only means of establishing the true state of mind of a person is the testimony of that person. Evidence of true intent is likely to be unreliable and colored by self-interest. Therefore, in deciding whether a person agreed to a contract, the law gauges intent objectively. That is, it evaluates the person's overt acts, words, and conduct to decide whether they reasonably signified an intent to enter the transaction. And this is throughout this book. And Jack and I and Brandon are going to do some contracting here shortly. Because you've got two sides to the game we talk about. You have a paperwork side and you have a practical side, or the application. And for some of you that are considering, well, I'm going to go in and take care of my traffic ticket. Really? You're going up a contract law expert. Some of you play basketball, some of you play chess, some of you are excellent at other talents and things. How well does an amateur stack up against anybody that's good at something? It's not pretty. And I can tell you that you amateurs that go before a judge, it ain't going to be pretty. And it's that bad because you don't have any experience at it. You hear the words, but it was really cool because we had one of Jack's guys at the last seminar in Elgin. He's 20 years listening to Jack, and you're listening to a pro. And Jack has gone over this stuff only about 100 times. The guy says, I think I can handle it. I made them all write down how you come into court. I said, use your notes. It's okay because you can use them in court. He still couldn't do it. Then he goes back and Jack says, did anybody go down and see Gordon's deal in Elgin? Yeah, I did. And oh man, he was worse than you, Jack. No, we're all the same. It's the greatest show on earth to go in there and work with these wonderful people. Shakespeare said it, all the world is a stage and all the men and women merely players. Well, you're up on stage and that's what we're going to do right now. We're going to play contracts. Y'all like to play house and do other things. Start playing contracts. And I'm telling you, it's so cool when you get into this game and you need to play. When we tell you to practice, I've got students, it's a big difference. Some of them, they go down to court, sit in and watch what's going on. They go, God, it is contracts. This is so good, Gordon. We hear the judge say these things, all the buzzwords, and they're seeing it. And they're getting used to the court and this kind of thing. You get somebody like Julio. He comes, he listens, and he didn't exactly know what to say, but he did know exactly what to say. I just got to ask questions and bring mine back up. And that's what he kept doing. And it's really strange to have a discussion with somebody when Judge Smith is saying, I'm the judge, here's Defendant Smith. Mr. Smith, you've been charged with a crime.
And?
How do you want to plead?
And?
How do you want to plead?
And?
I could put in a plea for you, not guilty. If you're not going to plead, I'll do it for you.
Well, I conditionally accept that you say I've been charged with the crime on proof of claim that there's a charging instrument. Does the court at this time have a charging instrument?
We're not going to listen to that crap. You know, this is it. What do you got to say, prosecutor? The mic? Oh my God.
Tasting 1, 2. I guess we're almost done.
So we're going to do a little court action here, right? So we got to get the court set up. This is going to be kind of fun. Y'all get to play a little. This gets fun.
What's the first rule? Aren't you supposed to begin with do a full acceptance? But if he hasn't shown me anything, what am I accepting?
And there's all sorts of cool stuff those judges do.
Pardon? You do the first time you're presented something, you have to do a full acceptance because we need to set off, settle, and close the account. The only thing that the court or anybody else is doing is they're allegedly bringing a charge, right? See, it's either accusatory instrument or it's a charging instrument, or it could be an indictment, an information, a complaint. Whatever it is, it creates a commercial stress. By a commercial stress, it means that there is commercial energy there that is supposed to move from one account to another account to zero something out. If you zero the accounts out, it goes away. Does that make sense? And remember, isn't everything that's going on out here in a democracy? Isn't a democracy a military government? What was the purpose of the military government? Maintain order. It overruns the de jure government because there is an emergency where that de jure government can no longer lawfully or legally protect persons, places, and property. So the military has to come in under an emergency, displacing the civil government. So when the lawful government is displaced, which is called de jure government, J-U-R-E, then you have de facto government. If you look up de facto, it exists in fact, but is not legal.
Not legally established. Get down there. We got to get rolling. You're being arraigned. Now get off my bench.
What the hell kind of judge is this?
You all are the gallery. And Mr. Smith's going to go out in the gallery there.
Aye, your potentate. How may I assist you?
Just get in the gallery. Now over here, I've got the prosecutor. He's sitting there, and I've got my clerk over here. And these are the bat doors coming in. This is the gallery. You're all in the public gallery.
I better get behind the bar.
Now, there's a lot of things that can go on in court, including we're not even going to call the case. Is Mr. Smith in the courtroom? Judge might just come out and say the name. Is Mr. Smith in the courtroom today?
Your Honor, may I ask and inquire what this is about today, sir?
Are you Mr. Smith?
And with regard to what would this court be looking for Mr. Smith?
There is a court case here before me today. It is, matter of fact, I'm going to go ahead and call that court case. He didn't volunteer into my jurisdiction, Mr. Smith. He just, what's that about what it is? That judge pulled at him. And I stood up and said, I'm here today as paramount security interest holder, blah, 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 and if it please the court, can I enter the bar and all that kind of stuff, and the judge just let me stand out. But he listened to what was said, Mr. Smith in there. Well, what do you want Mr. Smith for? What about it? Did I say I'm the judge? Anything. We've got a court case today here, State of Sheraton versus Mr. Smith.
Good afternoon, Your Honor. I'm Mr. Adams, prosecutor for the State of Sheraton. Seems that Mr. Smith has neglected to pay income taxes for 7 years. Damn. And the state is seeking sanctions and is also seeking banking information. We would like to do a series of discovery, find out where Mr. Smith's assets are so that we may levy and charge him for the past taxes for the last 7 years. Looks like he owes $80,000, Your Honor.
Is Mr. Smith in the courtroom?
Your Honor, I am here today as the authorized representative for the secured party creditor over
Your Honor,
Mr.
this is just
Smith
a bunch of
and,
gibberish. He sent me a bunch of paperwork with this secured party, whatever. It's just nonsense. This is the defendant. We need him to come into the bar so that we may question him, take the stand. We need to do a series of discovery and find out where his assets and accounts are.
Is this the crap paperwork he sent in?
That's it, Your Honor. It's ridiculous. It has no legal meaning whatsoever.
I got it from Gordon.
We had a prosecutor started right out of the chute. That's BS. There's no such thing as a secured party creditor. I certainly agree with you. This paperwork is exactly a bunch of gibberish. Is this one of that patriot baloney stuff?
It's, Your Honor, it's something off the internet. Mr. Smith is trying to avoid paying his taxes. He may even be liable for criminal charges of tax evasion. It's an internet scam, Your Honor.
Sir, can you just please be quiet in my courtroom?
Aye, Your Honor.
I'll have the bailiff arrest you if you're not, or remove you from the premises, and we'll just go right on ahead with this. Now, in your opinion, Mr. Prosecutor, how long has this stuff been going on, and how many charges do you intend to bring?
Over 7 years, Your Honor. Right now, it's civil, but if Mr. Smith is not willing to cooperate, we're going to be seeking criminal charges against him for his evasion of his tax liability.
Have you tried to work this out with him at all?
We have, Your Honor. We've sent several notices. Every time we send Mr. Smith anything, he sends back junk, meaningless paperwork with just a bunch of nonsense written on it. I can't even understand it, Your Honor.
Nonsensical stuff.
Completely nonsensical.
Now, you think this is it's interesting because I'm going to tell you. Jack and I got a client down in Texas. We've been going in and out of court with this guy. He comes into court, and this is exactly what went on. He says, I'm here. Prosecutor just starts yammering away. Just talked right over him like that. Now, Mr. Dwight shushed his mouth, just like Mr. Smith did, and we're carrying on this thing. And we're having this doggone it and on back and forth and back and forth. And our guy out here is cringing worse and worse. More of this baloney, more of this stuff. I'm going to tell you something, Mr. Smith.
How long did that, going back to our buddy Dwight, how long did that hearing take? It was about a half hour or more, wasn't it?
I think it was like 15, 20 minutes. So here's what the judge is saying to Mr. Smith, and I'm going to do it.
Okay, go ahead.
Mr. Smith, I'm not going to accept any more of these conditional acceptances. This is after the prosecutor. We're not going to have any more of these conditional acceptances. I'm not going to finish up today, but I'm going to tell you what. If you show up in the next hearing without an attorney, I'm going to have you arrested. If you don't have an attorney, da-da-da. If you don't do this, I'm going to do that. I'm not going to accept any more of your conditional acceptances. I'm not going to do any more. Let me see if I've got it here. It's really so good.
Do I get to play Smith or Dwight?
Oh, you can be, you're going to be...
Either one?
I tell you what we're going to do is the first thing we're going to do is we're going to have him be Dwight, exactly what happened with that, all right? You remember what Dwight did. So this is our hero, and he's doing the best he can, but he's listening to this diatribe by the judge. And our guy has set all this stuff off, done a wonderful job doing some beautiful things, but he's not handling this well because he's just cringing more and more and more with this wild stuff that's going on.
See, we didn't help Dwight a lot because we told him it was his hearing and he had to take control. And he was dying to get in there and take control. And every time he spoke up, either the prosecutor or the judge interrupted him. So he was really frustrated.
He tried to speak in. We just overtalked him.
Did they know he was coming?
Oh, yeah, they were ready for him. They were waiting for Bear.
Was there anyone else in the courtroom? Was it empty? Was it just them?
I don't know. It's really immaterial because they just played a number. You'll see what the judge did here in a minute. And then I'll be Dwight. And you tell us whether Dwight did good or not. See, Dwight went in there and he had a record for set-off settlement closure, which means he went in there as the creditor. And if you stick around in a hearing talking about debtors as a creditor, isn't your conduct one of accepting the role then of the debtor? And so he was getting really upset because as his hearing went on, he tried to get in his words to take control of the hearing. And the judge and the prosecutor were not letting him speak because they knew what he was going to try to do. So they just kind of like stood there and interrupted him all the time. They were even
He tried to
discourteous.
get it a word Judge Wise.
Judge, could you let me go on the record, sir?
No, I'm not talking to you right now. Look, this is what we are. I'm not going to be accepting any attorney. I'm not going to be accepting any more of this private paperwork. Matter of fact, I'm going to probably revoke your bond. I'm also going to...
Probably
going to revoke the bond. I'm going to have the defendant arrested for failure to hire an attorney.
Sounds like I've got a right to contract to me.
I'm not going to accept any more of your private administrative agreement stuff. I'm not going to accept any more of your conditional acceptances. And we're going to set this for on the next docket. And you better have an attorney or I'm going to have you arrested, etc., etc. Now, do you understand me? This is what Dwight did. Do you understand me?
Yes, Your Honor.
Good. Case on.
How'd he do?
We beat him up for 20 minutes.
Why are you laughing at Dwight? What did I just agree to? I just took the offer and I didn't conduct my hearing. So am I the debtor or the creditor? Oh,
now, Dwight's going to have to heal this back up. So Dwight, with some guidance, put this conditional acceptance together based on that hearing. Because the prosecutor and I had this lengthy diatribe about this baloney, this stuff, shuck and jive. I'm not accepting.
This was his conditional acceptance.
This was the
right?
conditional acceptance
Okay,
we gave him.
Let's read into the record what Dwight did after he said, okay.
After he
Because
blew
it's important you understand this.
And he went back and he said, hey guys, I think I did okay.
You have 3 days on a contract. So we know that the judge made a contract with him. And like we tell you, don't panic. We can come back in and fix it up. So he called us up, explained what happened, and we call it the toothpick question. There's 15, 20 minutes of the judge, the prosecutor talking, saying we're going to do this to him, we're going to do that to him. He ain't got anything coming, and I'm not going to be accepting any more conditional acceptances, and I'm not going to this, and I'm not going to that, and I'm not going to this, and all of this stuff after he just beats him with words. Do you understand?
Okay.
Do you understand me? Yes. End of hearing. Dwight comes home.
Okay.
Now, we have to go back in. So this is the conditional acceptance that Dwight did.
Okay, before I read this, Dwight came back on the phone after the hearing and he said, this is what happened. How do you think I did? And then he said, you know, this hearing did not go the way I thought it was going to go. And we go, hey, smart analysis, okay? He said, I was supposed to go in there because before the hearing he did a conditional acceptance that he was going to show up at the hearing conditioned on proof of claim that this hearing was solely to bring his record of private settlement before the court for set-off and closure.
That was the agreement. He had
That's
sent
the
that
agreement.
conditional acceptance in. The judge had it. The prosecutor had it. Nobody responded to it. So this is the way we began the hearing.
So they did everything except allow Dwight to take the floor and ask for his remedy. He tried and they interrupted.
I would use a different preposition on there. Instead of bringing a record for settlement and closure, I'm bringing my record of settlement and closure.
The record is belonging to the settlement, which has already taken place.
Right. So
okay?
it's almost, if you use that preposition for, you're suggesting that it's not settled and closed, that the record somehow is going to do it. But we do settlement and closure on the private side. Now, we'll get into how to actually bring in your private record into the court properly without prejudicing your rights.
Now, why are you even bringing a record into the court if you already settled it on the private side? You need a second witness. Remember, 2 or more witnesses. So you settle it on the private side. Isn't that in the Republic? But isn't half of this court centered in that foreign country called the democracy? So you got to get a settlement in both countries. Your private process settles it in private in the Republic. What does Scripture say in the New Testament to resolve your issue? If you have aught with your brother, what do? Take it to him how? Privately. Does that mean in the public court? No, that's public. Are you going into the court to settle your issue with your adversary? Beep wrong. You're in the wrong spot. You aren't going to get a settlement. You go into the court, the judge says, how do you plead? Why do I want to settle this in the public? First, I got to settle it in the private. So you go to your brother to settle it. How do you do that? With our A letter. We're doing the acceptance of your offer, and we're returning the consideration that you're asking for set-off, settlement, and closure. Have you agreed with your brother? Is there any argument that you've raised? No. So you're in perfect harmony and agreement. Why isn't your brother settling with you? 2 reasons. You're in the Republic, and he's a title of nobility, and he can't come there. That's number 1. But if you screwed up and you didn't do it right, doesn't he have a duty as a watchman on the wall to warn you that you got a problem? Is he going to walk into the Republic? No, he can't. He will send some stranger with a third-party message and says, we're returning your paperwork. This is a bunch of crap. What did they just do in the hearing? Oh, we saw his paperwork. This is crap. Did they return the paperwork to Dwight?
What did they do to Julio? This is just gibberish. Did they return it?
No. If they kept the paperwork, they're liable on the paperwork. They didn't return it.
There's agreement.
It's commercial process. So they lied, but their actions speak louder than words. Their actions said, we're keeping it, you're okay. But to your face they said, this is a bunch of crap. We don't understand it. It's a lie. We're not going to accept it. Well, excuse me, your actions already kept it.
And what did Gordon read out of the book about your words in showing intent in the contract?
Check this section out. This is under silence or inaction. Jack just told you, you A for V. You gave back consideration, right? You tendered what? Your bond number for set-off. They gave you a charge, a bill. This is so critical. This is on page 65 of this particular version, but under silence or inaction would be in restatement second anywhere. It would have words similar to this. There are two situations in which silence binds the offeree, even in the absence of intent to accept. But it's important you have an understanding of the word acceptance. An agreement either by express act or implication from conduct to the terms of an offer so that a binding contract is formed. What kind of contract?
Binding.
So, I don't care if you're silent or not. Now, if the offerer, brother prosecutor, the offerer gave to brother Smith, proffers property or services with the offer, and the offeree,
Me.
having the reasonable opportunity to return or refuse them. Now, if he got it and he gives it back, who's the offeree and who's the offerer? It's been reversed, right? Exercises any ownership rights over the property. Did he keep your A for V, R for V? Did he answer you? Sounds to me like we have an acceptance which creates what kind of contract? You don't have to memorize this stuff like some of us do. You just need to know if they keep it, we got a deal. If they go silent, we got a deal. If you go silent, policeman says, you Gordon Hall, the murderer that just killed 6 people down on the street down here? I'm taking the fifth. You're Gordon Hall. He's going down. I thought he was Brandon Adams.
And he hasn't rebutted the assumption you murdered the people down the hall, so that's probable cause for arrest. That silence is really powerful.
Any ownership rights over the property?
You don't want to use it unless you are statutory and you don't want to confess, but you aren't rebutting the assumption.
Door 3, it'll kill you every time. Ownership rights over the property or keeps the benefit of any service the offer is accepted. The offer is a what? A binding contract. So, prosecutor, he files a charge, a nice indictment against Brother Smith. I'm the court. I'm no fool. I'm a creditor. First thing I do is send it out to Brother Smith. Brother Smith gets that thing.
Offer.
What's he going to do with it?
Do an acceptance. Do you have a pen, brother judge?
He's going to write on this thing and he gives it back. He sent it over to his brother.
Because
and he gave me a copy.
Now let's make a distinction here and be clear. Who made the offer? Was it the court, the judge, or the prosecutor? The prosecutor. So who is Mr. Smith going to return his process to? Right, because we're doing a what kind of a process? Administrative on which side? Private side.
You got to get your brother to agree with you, not the court. The court
now he gave it back to the brother, but I'm the court, and I also see a copy of what he gave to him, and I see the certificate of service that he sent it to his brother Adams, the prosecutor. I know that he did that. Nice deal. That's in his hands. So guess what? Now we're in this court, and we're under some kind of a contract. And in this particular case, Dwight had made a deal and sent him some stuff, said, hey, the next hearing is going to be merely for the purpose of adopting the private record as a public remedy for set-off settlement and closure. They saw that. He comes into court. We're not even going to let Brother Smith get started this time. Him and I just carried on what we call the toothpick question. We're going to harangue for 15, 20, 30 minutes about what an evil guy this is, everything else, beat him down, talk about revoking the bond, all the things that strum him, scare him, revoke the bond. If I don't hire an attorney, I'm going to be arrested. All the sparklers, and Jack says it eloquently. We got an aircraft carrier going down the lane, and we got all these battleships and jet planes. Comes under attack, man. They shoot all this chaff and stuff out there to take away from your goal. The goal is, Dwight was there on his issue. So the prosecutor and the judge had a whole 20-minute, whatever, 30-minute, 15-minute diatribe. And then they turned and said, do you understand me? Yes. And this is what we had to go back and put together.
Okay, the toothpick question is, if you will accept the order of the court, you just granted personam jurisdiction. So the judge said, do you understand me? And you said yes. So you just agreed that you have appeared to the judge's order. If you can follow the judge's order to answer his question, then you can follow the order to be sentenced on the crime.
Your Honor, are you asking if I am clear on the language you're using and the meaning of the words?
That's counteroffer.
That's counteroffer.
Do you understand
Confession
or do you
and avoidance.
stand under? And Dwight says, yes, I do. I stand under, I got to hire an attorney. I stand under the next hearing is for this. I stand under this. I stand under that.
Give me the toothpick question.
Do you understand me, Mr. Now this is, Mr. Smith is not going to do a Dwight. He's going to do his own thing. Now, after I diatribed and arrest and this and that, do you understand me, Mr. Smith?
I am the original Dwight, not the other Dwight.
Don't give me any lip, Mr. Smith. Do you understand me?
Your Honor, thank you for allowing me to speak. Once again, I am
Thank
here
you for
today.
now. Do you understand what I'm saying to you, Mr. Smith?
Your Honor, thank you for allowing me to speak in this court today.
Do you understand what I just said to you?
Your Honor, thank you for allowing me to speak.
Now, who's going to get tired first, him or I? I want to get tired,
Your
not
Honor,
him. He just picks it back up
Thank you
again.
once again for allowing me to speak today. I am here as the authorized representative for the secured party creditor, who has a security interest in the defendant. But please just refer
Your
to
Honor,
me from
it's
now on
a
as defendant.
more nonsense, meaningless word. What? What is he talking about?
Mr. Smith, do you understand that we have a hearing next
Your Honor,
on the 30th?
thank you for allowing me to speak here today at this hearing.
You think that's, I'm going to tell you, that takes, it's like something goes in that imprinting you got when you were younger, and he keeps coming back to his issue. He's not going to give me one iota, because I'm going to have to let him finish pretty soon.
Listen, the way this is going to go is either I'm going to be allowed to speak at the hearing, or I'm going to be drug out of the courtroom and the record's going to show I did not have an opportunity. If the record shows I did not have an opportunity, they better be releasing me, because they have no lawful authority to hold me. Now, didn't we tell Dwight, this is your hearing today? What happens if he leaves that courtroom without addressing his hearing? By his conduct under contract law, what does that say about Dwight's claim? It says that he's just abandoned his own claim. So as the Dwight instead of the other Dwight, I cannot leave this hearing without addressing my claim that I'm here for.
Do you understand me, Mr. Smith?
Thank you, Your Honor, for allowing me to speak here today. Is there a stenographer taking this record?
Does it matter, Mr. Smith? Do you understand me?
Thank you, Your Honor. May I address the court uninterrupted?
No, just, we've got a hearing planned for on the 30th. Trial starts. You going to do it or not? You going to be there, or am I going to have you arrested?
Thank you, Your Honor, for allowing me to make the record today. Will the court allow me to make the record, or is the court going to deny me the opportunity to conduct business here today?
Jeez, go ahead then. You know what? You think that's, I'm telling you, that judge is going to put, if you think I'm mad at you and the judge is mad, people lock up and they don't want to make the judge upset. So he might just do something like that.
How about our favorite student that when the judge said, just get in here, he walked right in because he didn't want to make the judge mad.
Oh, this was classic. One of our students, he's doing great with his case. He starts to introduce himself out in the gallery. The judge says, and I was there, this tone, Mr. Smith, just get in here. That's all it took. So here's
right
the back doors. So he's talking to Mr. Smith, get in here.
I'm in the bar. Then the judge said,
hold on, this is even better. So my guy's going to be real bold. So here's the bar doors. There's the judge up there. He turns around and he backs in like this. He goes, I conditionally accept. This happened. I conditionally accept on proof of claim, blah, blah, blah. I'm sitting right here in the gallery. I'm looking at him going. And he turns. And so he says, now I say, and the judge says this, now get over there and stand next to your attorney.
yes, boss.
He walked right over there. And then he says, may I say something, Judge? No. And the judge and the public defender carried on a whole thing.
Now, why could he deny him from saying anything?
He's a debtor.
He has an attorney. If you have an attorney, you can't talk. You're no say. You heard a pro say? You're no say. You
Here's
got
a
no
classic.
speak, no words.
Here's a classic one. I went with a friend of mine in L.A. And we've warned you about who you are inside. This guy was the guy who introduced me to this stuff. Knew a lot of stuff, but I went past the teacher. So we're in L.A. He's dealing with a diamond theft deal and something. He got a little stupid at a store and been. It doesn't matter. So he files a bunch of UCCs against the prosecutors and some people wasn't supposed to. Gave them to the court that morning. The court gave them back. He shoved them down their throats and give it to them. So the court didn't start for like an hour and a half, 2 hours, and the attorneys kept coming out and talking to him. And I said, look, dude, quit talking to him. Stranger danger. But he wanted to impress him with his knowledge. So the court gets started. And he says, I'm here today. What did he say? I'm here today as a third-party intervener of so-and-so for the purpose of helping the party settle all claims. And he goes into this whole long thing of introduction. And the judge goes, what? Judge just said, I didn't hear anything you said. What? And he goes, I'm here. He goes, just come on in. You think you're just going to resist that? I'm telling you, you just almost automatically go. He goes, just come on in.
And that's actually, just so you know, that's psychological. Like you sometimes you see me up here and I'll ask a question and I'll go like this and watch all of you raise your hands. It's psychological. I know this because I've been trained in training people that if I do this, I can get everyone in the room to stand up. If I do this, I can get someone to come up front. It's psychological. You don't even think about it. It's second nature. And the judges, they got a bag of tricks of things to use on you. They know when they yell, you're going to go into a childlike state. You're going to automatically see them as a parent authority figure when they start yelling and pointing at you and looking down on you. Why do you think they're so high? It's all psychological. You got to remember we were talking about being below that line? You got to get off of your beliefs and get off of your reaction so that you can be present in the moment and not react to the just come in. Think, what just happened? That's an offer. Identify it. Make the distinction. I can ask a question. Well, Your Honor, may I enter the bar while reserving all my rights? Remedies, titles, interests. Judge says, just come in.
He just told you no. Come in.
Let the record show that I'm entering the bar while reserving all my rights, and the court has not rebutted or objected to me entering the bar whilst reserving my rights. I've seen you. Oh, stop right there.
They've done that.
Yeah.
We had
They'll
one
tell
student.
You stop right there.
Why will a judge do that?
Because he can't let you into the public.
Does he
reserving
want
your private
anyone
rights.
from the republic in his jurisdiction that he's talking to?
No, because you can all, as soon as you get in there, treason. Bailiff, arrest this man. We're gonna have a hanging.
We had one student. Judge says, get in here. He says, can I enter reserving all my rights? And he's starting to walk into the bar. He's just bolting in without a deal. And the judge says, your constitutional rights are reserved.
Ooh.
And he walked on into the bar. You don't have constitutional rights. You have constitutional securities and protections.
No,
right?
you don't have either of those. You have God-given unalienable rights. Constitution didn't give you any rights.
You're not a party to the Constitution.
Yeah, you're not even a party to it. You have God-given unalienable rights. Don't look to the Constitution as your document.
The judge sometimes say, you got all the rights you've got. Get in here.
Or
what kind of an agreement is that?
Or even more deadly, civil rights. Watch out for those. Those are benefits and privileges.
So you're going to see all sorts of tricks. And I've had the judges, our guys introduced, and they say, come on in here. And as soon as they get to the thing, the judge goes, stop. Just like he just did. So it's really interesting, and they don't do the same thing at all anytime. I've been to so many hearings, it's never been the same yet. It's so cool because it's so varied. But if you stick with what these guys are telling you, just like now Jack, let's go back to Dwight. Jack, I told him, do you understand me? I told him all sorts of things, and so...
I wasn't listening to him. I was here for my business. Thank you, Your Honor, for allowing me to speak today.
Go ahead. You're on now, Jack. Go ahead.
I've already succeeded. By even saying that, then I introduced, is the court not ready here to adopt the record?
I just told you that we're going to be setting a hearing for 30 days from now for trial, Mr. Smith.
I conditionally accept that on proof of claim that the court is not involved now in delaying and in harassment and in barratry and malversation.
Malversations, corrupt conduct, or fraudulent practice
And
as
I was
in
nice
public
when I
office.
said it.
Your Honor, do you understand anything that he's saying? I can't understand for the life of me what the hell this man is talking about.
What have you got to say about that, Mr. Smith?
I conditionally accept that and proof of claim that the prosecutor really didn't mean that he agrees with adopting the record and that the court will now adopt the record.
Your Honor, I don't agree with anything. I don't know what he's talking about. There's no contracts. He keeps talking about contracts and agreements. Your Honor, there's no meeting of the minds here.
Listen to what's going on. Who's creating a controversy and who's in harmony? Who's the creditor in front of the judge and who's the debtor? Okay, now based on contract law and based on conduct of the parties, I just said on proof of claim that the prosecutor is not accepting the record and moving forward. And what did the prosecutor just do? Argue, which means he's in dishonor, which means he accepted the record. So is the prosecutor in harmony with me?
Yes.
See,
absolutely,
but
under contract law.
I'm the judge, and I know that my guy's arguing, but I need him. I said, do you want to explain that, Mr. Smith?
But I came back and I said, I conditionally accept that I have to answer the prosecutor's question on proof of claim that he's not in total harmony and agreement with adopting the record.
Your Honor, again, with these agreements, and I have no idea what he's talking about, Your Honor. I know of no agreements. I've not signed a contract with this man. There are no agreements that I'm aware of that he's talking about. It must be these silly paperwork that he's putting in, these conditional acceptances, these notices of fault and certificates of non-response. It's all meaningless, Your Honor.
Groundhog Day!
Well, Prosecutor Adams, I'm going to have to agree with you because in this courtroom, there's nothing in the statutes that provides for, like you said, a bunch of frivolous and gibberish, etc. Mr. Smith, I need you to explain to me, you just explain it to the prosecutor or myself, what you mean by this paperwork.
I conditionally accept
Now,
that.
I need him to make an explanation why. Because I need him door 4.
Thank you for allowing me once again, uninterrupted, to take the floor, Your Honor. Thank you for that swat. I needed that.
You want to explain it, Mr. Smith?
I conditionally accept on proof of claim that the learned prosecutor hasn't got legal advice and counsel to answer his question for him.
Mr. Smith, I am the legal counsel here, so do you want to
Then
explain this
take
paperwork?
back that statement, Your Honor.
Do you want to explain that
wrong way.
conditional acceptances, Mr. Smith, to
I
the court?
conditionally accept, Your Honor, on proof of claim that it's necessary to adopt the record as the court not got all it needs before it at this time to adopt said record in the
Your Honor,
public.
who talks like this?
I got to tell you something, Mr. Adams. In this courtroom, we don't talk like this. I don't know what this stuff is he's talking.
This courtroom's in the public, the courtroom's in the private.
Your Honor, I move that we set this for hearing. The next available spot on the calendar will be good with me. This is just nonsense. It's going nowhere. I suggest that maybe we get a mental competency hearing for the defendant, appoint him some public counsel.
Obviously, Mr. Adams, I can definitely see that. What I'm going to do, Mr. Smith, is I'm going to set this for a hearing out 30 days from now, July 29th. I'm going to expect you to voluntarily go get yourself a mental competency test, and I want to see a letter from a psychologist that says you're not crazy. Do you understand me? And I expect to see you here July 29th at 10 a.m. And do you understand that? Because if you don't and you're not here, I'm going to revoke your bond. Do you understand me?
Thank you, Your Honor, for allowing me to address the court again today. As the defendant is so stipulated, I conditionally accept all of that on proof of claim that by setting off, settling, and closing the case, that does not demonstrate,
Your Honor, more nonsense.
that the defendant
I motion
is competent.
that you issue an order for a competency hearing. Clearly, we're not getting anywhere with this man, and clearly he has some kind of mental disorder.
I'm going to tell you, when this deal that the judge and this prosecutor know, if it isn't somebody that's well steeped in understanding, it's your imprinting that's going to kill you. Because this guy over here, Brother Smith, he knows his rights.
And he's cool. He's cool. Because usually, judge and a prosecutor going like this, I've watched our guys just fall apart.
This is what we call a cucumber, a cool cucumber. So, but you notice he's holding up. He's just going to patiently wait. He lets me and the prosecutor.
Am I worried about going to see a psych? Because I'm going to ask the psych how I can help him.
Well, I'm going to go ahead and adopt that, Mr. Adams. I think we're going to go ahead and order a psych report. I'm ordering you, Mr. Smith, for a psych evaluation, and I will give you the name of the psych and send it over to you. And we'll then reconvene after that's been done. All right, sir?
I conditionally accept that on proof of claim that you have any competent party to petition this court to give you the jurisdiction to issue that order.
I don't even know what that means, Your Honor. Are we coming back on the 30th, or are we going to reschedule after the psychological exam?
Mr. Smith, we're trying to help you. And before you hurt yourself, might I suggest you get yourself an attorney, sir, because this is not going to... Now, one of the other ones we like is on a mental competency is we conditionally accept your offer of a mental competency exam on proof of claim that tendering a private set-off for settlement and closure of an open account to protect the public from any further liability in the matter constitutes incompetency. Or just like he did, he gave a beautiful... Remember, there's just 375,000 ways to get this done. But the important thing is, he's not going to go out of here without having the last word. Or if it does, and I have the last word, there is nothing. And I might just jump up, and we've seen it. We're going to go on haranguing, and I just said, that's the way it is. It's the 30th. That's the end of it. I'm out of here. Court adjourned. And he's gone, never giving him a chance to say anything.
But I've got 3 days to get my paperwork in. Am I worried? I'm Alfred E. Newman.
Because what he's telling you is even, and the judge can pull that, you didn't get a chance to say anything. Well, that's why what Dwight got to do.
Before we go into that, let me say the following. Here was Dwight's problem. He knew it was his hearing, right? And he had to get on the record.
Now, he thought he was going to go in and get a chance to speak,
right,
and the judge would be calm like ever before, but he wasn't.
Okay? Because they can start seeing how you are understanding the role you're playing as the creditor to protect yourself. And what in military strategy, what is the advantage of the attacking army? Isn't it to draw you off guard and to attack you in a method or place or by some power or force that you do not expect? Because a surprise attack, when you're not expecting that, is going to inflict a lot more damage and hopefully defeat, rather than coming back the same way we've been playing the game You're getting comfortable. You think the judge is listening to you, and so he's going to test you. Well, there is an expression. The first will be last, and the last will be first. Every time you read judges' orders or attorneys' papers, go to the bottom and read up in order of importance. The last is first. The first is all the public crap. The first is the chatter going on between these two guys. This guy's crazy. His paper is crap. He doesn't know what he's talking about. Why are they doing that? To get you unsettled. To take you off your comfortable position. Oh, I got to argue that my paper isn't crap. I got to argue that issue because they brought it up. No, you don't.
Did you hear what he did on the last one? He says, I conditionally accept all that because I harangued on a whole bunch of stuff. So instead of trying to answer each one, he says, I conditionally accept all that on proof of claim.
So here is Dwight, and he's thinking, I got to get to my business because if I stay in this court on the business of the debtor, I'm acting like I'm the debtor, and then I'm not doing my conduct. So he's trying to butt into this argument between the judge and the prosecutor who's talking all this smack about the debtor and the defendant and how this guy in front of him is an idiot. And Dwight's trying to butt in, and they keep shutting him down. And then finally the judge, do you understand me? And the judge is quiet. This is Dwight's hearing now. The last will be first. Dwight, you've been given the floor. Do your business. What does Dwight do?
Yes.
He answers their business. Dwight, but I thought they were going to give me the floor first. You thought wrong, Dwight. Why are you interrupting their hearing? They were talking about a public hearing about a debtor. You're bringing in a credit to resolve a different matter, the one in private. The judge gave you the floor, sat back because he's got to let you speak sometime, and you said, well, for my business here today, Your Honor, I bow to your job. Yes. Dwight, you just threw your hearing away. You asked for a hearing, you threw your hearing away because he assumed there's that comfortable little position. It's my hearing, I'm going to go in and talk, and I'm going to go home. Oh, they flipped it around. They held their hearing first. And you tried to interfere with their hearing. When they gave you an opportunity for your hearing, you abandoned your hearing and gave up. The question?
Who's going over there?
Mike?
Hold on. Let's make sure you have mics before you ask a question. We'll do this one, then we'll come over to you, Scott. Sly, go ahead.
Okay, so backing it up, when he first stood up and said, I'm the what do you say, authorized representative or
Right.
something to that effect. What happens when the judge then says, okay, so who are you then? If you're saying, yeah, I'm the authorized
Let's try it.
representative, Mr. Smith.
Okay, Jack, is Mr. Smith in the courtroom?
Well, thank you, Your Honor. Let the record show today I'm the authorized representative for the secured party creditor over the debtor having a security interest, but just refer to me as defendant today. What did I just do? I defined the term defendant to be creditor.
Just an offer.
The judge going to argue you can't be the creditor in my court? What would I say? I conditionally accept that, Your Honor, then that you don't want the defendant here today. Is that what you're telling me?
Let's try this, Jack. You just said your speech. Who are you, sir? You just did, I'm the authorized. Who are you?
Your Honor, I am the defendant as so stipulated. Does
What
the
is your
court
name?
have a problem with me appearing here as defendant today as so stipulated?
What is your name?
Your Honor, I am here as the authorized representative in the capacity of settlement. Is a name relevant to these proceedings?
Are you going to give me your name, or am I going to issue a warrant for the defendant, or an arrest warrant for the defendant?
Is this court going to deny the defendant an opportunity to address the court today, sir?
We're not denying any defendant. Are you the defendant?
Well, if the court is not denying the defendant, then is the court ready to proceed, or is the court going to continue to harass the defendant?
Remember, he defined defendant differently. He started out, and I didn't rebut that.
Did anybody rebut my definition? Then why would I abandon that?
Gets pretty heavy. And so these are the kinds of rote conditional acceptance you're going to need in your repertoire.
Oh, Judge, you got me so scared. Could I just creep into the bar and take my punishment?
That's what most do, maybe not with the words.
Isn't this adversarial proceedings? The only problem is we brought remedy to the court. We're not an adversary. Who is causing the commotion in this court? The judge and the prosecutor. It's their court. I'm not going to tell them they can't do that. I'm just going to continue to rebut their accusations, which is trying to drift me into acceptance of the court authority from the public sector. Because if I accept the public authority, now I'm a debtor again.
Hang on, Julio. Scott?
Yeah, I guess what I'm curious about is if you're doing a public service by set-off, settlement, and closure, why is the prosecutor and the judge so adamant to trip you up?
Because what are we doing in court? What is the purpose of the court? To what? Well, putting on the show for the public is the format in which they conduct business. Why are we in the court? There's two reasons. Because the court is a debt collection agency to fund the democracy. And they need to collect the funds. Am I preventing them from collecting funds? No, I'm voluntarily agreeing to allow the transfer. So am I obstructing the court in their first duty of underwriting the cost of the democracy by collecting fines? No, I'm not. So his question is valid because he said, if I'm doing such a good job, why are they coming after me when I'm trying to use the asset account? That goes back to the issue of what does the military do when they take over a land? Control. The military has to be in control for what purpose? Security. All of these space movies, these ETs, every time an ET comes to planet Earth, what does the military do? Round them up, capture them, put them in captivity. Why? Do they hate aliens? It's the nature of the military to control anything in their jurisdiction for military security purposes. Nothing personal, just have to control you. And so the issue in control is, will you accept the control of the military, or are you under an exemption from military control? Who's under exemption from military control? Creditors acting in the capacity of competent ambassadors.
What's competent?
Competent, what is competent?
See, we use competent a lot, and it's defined very clearly. Incompetent is not capable of handling one's own business. Competent is capable of handling one's own business. So if the judge wants to have a competency test, he's not concerned that you're crazy, you see green monsters. If you can't handle your business and you don't know how to say the right words and stay in honor, you are in fact incompetent.
What he's saying when he sends you for a competency test is you don't know the rules of the procedures that we're involved in. Now, when the judge and the prosecutor kept saying to defendant Smith, we're going to send you for a competency exam, what conduct, what words, what actions came out of defendant Smith's mouth which would demonstrate he was incompetent? Wasn't he actually handling all of his affairs? Was he doing it without any personal animosity toward any party? Was he in courtesy and respect to all of the officers in the court? Did he even interrupt them when they were interrupting him? When they made him an offer, did he come back and try to solve their issue with a counteroffer? What's incompetent about Defendant Smith? You see, they will get on you when you're doing it right, because what's coming out of their mouth is a lie, but when their actions are there, they will send us out, and the last thing the judge says is, we're sending you for a competency hearing. You know, I might wait there for 3 weeks and never get an order for one. Why would they send me to a competency hearing when I acted competently? And they know if I go to the shrink, what am I going to do at the shrink's office when I get there? He's going to invite me in and say, well, I got some ink blot tests for you to take. You know, that's Rorschach from Watchmen. And I go, oh, well, thank you so much. You know, I'd really love to take that test. I conditionally accept that if I took that test, it would help determine competency. But wouldn't it be better for competency if I conditionally accepted only to take that test on proof of claim that just talking privately, you cannot determine whether or not there is competency here anyway? In other words, if you obey the court order to take the test, didn't you just fail? Because when you obeyed the court order, what happened to your private rights? You gave them up. That just demonstrated that by obeying the court order, you're incompetent. So the only way you can pass the test is to give a counteroffer. But you know, if I took your Rorschach test, would that not prove that I'm incompetent by obeying a court order, giving up my rights of competency?
Mr. Psychologist Smith, before I get started and take this test that the judge ordered, could I ask you a few questions?
Yes, you may there, Defendant Gordon.
Is it not true that there's both a public and a private trust that run parallel in today's society, sir?
Gee, I don't know what you're talking about, Defendant Gordon. Could you explain that to me?
Are you saying you're unfamiliar with that there's policemen and judges on the public side and there's private people on the private side? Is that what you're telling me?
Well, that kind of makes a little bit of sense, but what you're telling me here just doesn't make it. I don't know what you're talking about, a private trust.
Well, is there not public people and private people in your mind?
Notice how he's only answering me with questions right now and not statements. Because I'm trying to get him to explain to me something, and Your Honor, we've got a prosecutor that's gone buggy.
I think we have a...
Whoa. Okay.
So this is something I did when I was initially out of prison, and there was a psychologist I was going to see, and I needed to break it off. So I said to him, would it be all right if I asked you a few questions? And this is going to happen. The psychologists sometimes will go along with it, other times they'll do this, because the test is going on right now.
See, what makes you think that the test is answering his questions? What makes you think that the test isn't your conversation with him about answering the questions?
Psychologist Smith, is it not true that the public has not the resources to resolve all problems in private?
Well, we know the public today just can't solve every problem. I'll give you that, Defendant Gordon.
Is it not true that the only reason that public trustees are involved in the remedy of any problems is because the private parties fail to resolve it?
Well, you know, it would be nice if the private parties did resolve it, but you know, sir, you're involved in a criminal case here, and I mean, that's not like a civil case. You've been charged criminally, sir, and there's certain rules and regulations you have to follow. And that's why we're here today. So are you going to take this test today, or am I going to have to report back to the court that you refuse to take this test?
Didn't you tell me I could ask you a few questions?
Well, you know, we've got a limited time here, sir.
How
And
about I
after
just-
all, the court is paying me to do this test. And so, sir, I'll give you one more question, and then we're going to get to the test.
Are you suggesting that the paperwork I provided to you that has resolved the matter privately still grants jurisdiction in the public to continue a matter already settled?
Well, sir, you're asking me to make a legal determination, and I'm a psychologist, so I can't answer that question. Are you ready to take my test now, sir?
Well, is there any reason to take any test since the private parties have resolved it and you have in your possession, do you not, the paperwork evidencing same?
Well, you know, the court ordered you to take this test, and if you don't take this test, I'm going to have to report back to the court that you refused.
I conditionally accept your offer that I'm refusing on proof of claim that we haven't just taken the test.
Well, it's obvious, sir. Are you ready to answer my first question right now?
Do I want to waste valuable public resources when the matter's already been settled? Wouldn't that be a sign of incompetency?
Well, I can see, sir, that you're just here to waste this time. So you're excused right now, and I'm going to report back to the court that you refused to take your test. You're free to go, sir.
And I appreciate that. And let me leave you my phone number, Psychologist Smith. This happened with me. I did one of these with them. I went back. A couple days later, the probation officer called and said, you call Mr. Smith back up and you set an appointment. I said, why, sure. Mr. Smith, hello?
Hello?
Yeah, I spoke with Mrs. So-and-so, and she said that for me to give you a call, so I'm rescheduling a time to come in and see you again. Would Wednesday at the regular 1 o'clock time be okay?
Well, let me ask you a question there, Defendant Gordon. If I put up an appointment time for you to come back in here again, are you going to answer my questions this time, or is it going to just be a repeat of last time and a total waste of time?
Now, what I had is I had a second one. I went in and saw him again. He said, let's have a talk. I said, before we get started, let me ask you a few questions. Didn't we go over this last week? Didn't we do this? And we're right back at it again. He said, never mind. About 35 minutes of we didn't go anywhere. I stayed standing. He stayed standing. We didn't start. I left again. Probation says, call him again. I call him again. And this is the third conversation. I said, well, why would it be any different?
Well, Defendant Gordon, you need not bother coming in. I'm still writing my report. I'm still telling the court that you didn't take my test.
And what he essentially said, well, there's no reason for you to come in, and I appreciate it. Goodbye.
Okay, now what kind of report did the psych write? There was a two-part report. The first will be last, the last will be first. The first, which is last, said that Defendant Gordon was totally out of control. He didn't listen to me. He wasted my time. It was absolutely a frivolous hearing, and I wasn't able to ask any questions. He didn't answer any questions, and therefore I cannot draw a conclusion. Paragraph 2. However, we had an informal discussion. The gentleman appears intelligent. He appears able to ascertain what is going on. He is verbally able to frame his sentences, words, and ideas in an intellectual manner, and I find no reason why Defendant Gordon is not competent enough to partake in the proceedings before this court.
Or
Such and
stand
such
trial.
psych. What just happened? Did he pass the test or fail? Passed the test with flying colors because he didn't answer the questions.
We had one of our students recently, real cool in L.A. She called me up. She says, the IRS just knocked on my door. I said, well, what did you do? She said, I was hiding on the bedroom floor in the back.
That's a win.
I said, you have got to get a grip, young lady. Now, Brandon knows who I'm talking about, and Jack does, because she called all of us in a blind panic. Oh my gosh, they're here, the sky's falling. I said, and so she finally got up the gumption to meet with him, and when she got done, she called me and she was crying because it didn't go very well. They left mad. I said, well, what happened? Well, when they'd ask me this, I'd ask a question like that. They asked me this, I'd ask a question like that. And pretty soon they were mad and they left. I said, congratulations.
First person to leave the field of battle.
She kept asking questions.
I have to bring up what her final question was. She goes, aren't I the beneficiary of the public trust? And they got up. Thank you for your time. And left. They didn't answer her question. They just left. But by the time she had asked that question, her confidence had been built up more and more, because every time they'd ask her a question, she had a question to come back at them with. Because I'm sure they were questioning her on her return and things like that. And when they would ask her something, she would ask right back, well, what's wrong with the return as it was filed? Is there something wrong with it? Is there a defect? Can you identify the defect? Can you tell me what's wrong with it? I've sent in letters. Nobody's responding. See, she was asking all the questions, and every time, that's why they were getting frustrated with her, because, for one, they expect you to be afraid of them. They expect you to answer their questions.
Whose hearing was that? Hers, because she took control, like a creditor. Beats hiding out in the bunker, doesn't it?
Put it up to your mouth.
Is it on?
Lift it, push it up.
Hello? Okay. I had situations similar to what happened in regards to having a psych evaluation 2 cases ago. It came after the judge kept warning me to get a public defender.
Sure,
I kept saying no,
you're incompetent if you got to take a test. You're incompetent if you need an attorney.
Now, hold on. You said you kept saying no. What's a better way of approaching that?
But
I conditionally accept your offer for a public defender, conditioned upon the public defender's acceptance of private compensation for his services. I would not want to burden the public.
Right. But I didn't.
Hang on. Now, if you provide private compensation, isn't that coming out of your asset account?
Mm-hmm. It's not a check or something or private money like you got in your wallet. He's talking, it would be a piece of paper with some ink on it you wrote drawn on your asset account.
Oh.
Now, we didn't discuss this today, but if it's coming out of the asset account, what kind of title do you have to those funds?
Legal and equitable, right?
Legal
Full title.
And equitable. Is that as good as gold? Do you need gold in the economy to function as a sovereign? Remember I said in 1933 they induced your mother to turn over your whole estate to the government.
Well,
that would have been,
maybe for you, Jack. I wasn't alive.
That would have been...
Yeah, me either.
I think I was almost a thought in my parents'
I'm denying.
mind.
I'm with you, Brandon. I'm in denial.
I'm going to confess and avoid on that one.
What I also want to know, when I went to the site, because I didn't know everything about conditional acceptance at that time.
Did you answer the question?
We had a good conversation.
Okay.
And I haven't heard from the court since then. That's what.
Did you answer the questions he gave you?
Yes and no. I did.
You answered a lot of questions, and some you might not have.
Right.
Did you do any conditional acceptances?
I didn't know about that then.
Okay, so you answered most of the questions, but you essentially acted like a debtor.
Did you ask him any questions?
Yes.
Okay.
Yes, I did. And like I said, I haven't heard anything from the court in over 2 years, so I guess I did okay. But the letter that I got was just as you stated in your letter, basically. It went through a lot of gibberish at the beginning, how I was incoherent and just then and like that. But at the end, he said, just as you stated, that I can't find a reason why he's incompetent.
There you go. So you're competent. Okay.
So
and the neat thing about the psych is that's the only purpose he has there in order to be an outside witness to demonstrate competency. And the competency that they're trying to demonstrate is that you understand, presumably, the rules under which they're operating, so that you can't come back after some adverse situation like conviction in jail and say, but I was mentally deranged and you shouldn't have allowed it to continue. So in reality, competency means you can function enough under the rules of court to be acceptable to subject yourself to liability. That's all they're telling you.
So the fact that you can't find the court, is that...
You got a mic?
No, I just took it. I've redistributed it.
What's the question? I'll repeat it.
Okay, if the fact that I haven't heard from the court in 2 years, does that mean that...
What was was it a traffic ticket or... You haven't heard from the court in 2 years on a traffic citation?
It's gone.
It's probably gone.
Yeah, because the
Probably.
concept of latches brings in, if a party has some course of action that they should really take timely and their conduct is such that they don't prosecute their case, they've abandoned it.
Inexcusable.
Now, that doesn't mean 20 years from now somebody may not show up at the old folks' home and issue you a citation to come in and pay the debt, but that just means, again, that you've opened up a brand new proceedings and you have all your rights, which means remedies. So you can do a full acceptance, or you could do a conditional acceptance on proof of claim. It wasn't set off 25 years ago, and latches has set in to prohibit your actions.
Latches is also defined as inexcusable delay in enforcing a claim. That cuts both ways. We're expected to enforce our claim if we're in a court. And if we don't do it, look out, just like they. So it gets interesting. Brother, you have a question?
Yes, my question is, Jack stated that the first person to leave the battle loses.
He who deserts the battlefield first loses.
But when y'all was giving an example earlier where the judge wouldn't let the defendant or the presumed defendant speak, and he leaves, the judge leaves, Jack made a statement, he got 3 days to reply because he didn't get to speak.
If the judge abandons the courtroom and I'm standing there, let the record show the judge just abandoned the courtroom and denied me my hearing.
Okay.
Now I've got that on the record. The stenographer's still doing something there. The judge ran tailbones out of the court. Okay, and so who lost the case?
The judge, because he
Well, the
left
judge
and he made
abandoned.
Well, the judge isn't
order.
a party to the case. The
He's
judge
not
is
a party,
a
he's
witness
just a
to the
referee.
case. And if I'm in there as a third party, I'm not the defendant, I'm not the prosecutor, well, maybe I'll take charge of that court. Let the record show the judge has abandoned his position. I'm hereby ordering.
Hear ye, the court is now in session.
I hereby order this case be dismissed with prejudice. Now that takes some cojones, but if you've got them.
Just real quick, doesn't the stenographer, as soon as the judge puts the gavel down, don't they quit?
Did the judge say court adjourned, or did he run off the bench?
A lot of times they just run off the bench, and you watch. The stenographer will continue to record what's going on.
And that is my question, if we're
And
trying to set the record.
They may even have an electronic recording going on, so when the stenographer stops, you think they stop, but it's still going on.
But the next thing is, if you order the transcript later on, you might find you didn't get the whole transcript. They may have cut off the last 5 minutes after the judge left just to see if you're going to come in and argue or complain.
In that scenario where the judge is not allowing you to speak, at what point, and I believe the correct word I'm looking for is, does procuration kick in?
You can't, what Jack, you saw him do, when the prosecutor and I are haranguing about him, Jack knows his rights. He's very comfortable that he doesn't have to interject. He's not procurating anything. They were clearly and purposefully cutting Dwight off. They weren't letting him speak at all. It was a tactic. It was 15, 20 minutes or whatever time it was of unabated conversation prohibiting him from, and it's not his to argue or worry. He can just stand there and be patient.
It was authorized representative bashing time.
That's what I wanted to make sure is that...
He's not giving anything else. He doesn't need
Whose
to...
court is it?
Well, yours.
Well, actually, the building in the courtroom belongs to the democracy.
Right.
And who's in control of that courtroom?
That courtroom?
The judge.
The judge, yeah.
Can he do anything he wants in his courtroom?
Yes.
Captain the ship.
Why am I interfering with them in their courtroom? Is that an honorable thing for a foreigner and a stranger to do?
No.
But if out of courtesy they will give me the opportunity to bring my side of the business, which is affecting them, and they give me the floor under common courtesy and rules of conduct, should they not allow me to speak interrupted as I allowed them to speak interrupted?
They should.
And
But
they're-
if they decide to cut me off, do they have the right to do that in their court?
Yes.
Why am I causing problems for them in their court? I'm there to solve their problems, not create them.
If they don't want him to speak, that's perfectly fine.
That's fine.
He's
I got
not
other remedies.
uncomfortable with that. Once you get relaxed about this stuff and don't get yourself all in a snit, you're going to be surprised that they don't have very many tricks in that bag.
What did Brandon tell you all morning? What are they trying to do with this play acting? You're going back to your little comfort circle, and your comfort circle says, I let you speak, you ought to let me speak, I'm really upset. Well, go ahead and be upset, but is that going to solve your problem? Get out of that comfort circle and do business, and do it with respect.
I just wanted to understand that at no point, I guess basically your conduct is what showed the judge that he didn't have to step in and handle your business for you, that you were competent enough to go ahead and handle
it was
your business.
determining whether there was competency. If I start getting in a snit and bugging them in their court, I'm not competent because I have no courtesy and honor. The question back there before is, why is the judge not allowing me to bring my outside asset funds to set off? Who can bring asset funds?
And remember, it's
Creditor.
what they do, not what they say. It is the judge's job, his duty, to protect the public. You're walking in to a public hearing trying to bring private remedy. Why? Exactly. Why? Why are you walking into a public courtroom trying to bring your private remedy?
That's really true. The only reason we have to be in any kind of harmony with them is to get the second witness. Do you have to show up at a public hearing to do it? There's good reason to believe, no, stay out of the public hearings and only do it in private. But let's say for some reason that judge said, we haven't seen that damn Dwight. Here's an order of arrest. You go drag him in here right now.
Now you're going to be
Now
in public.
you're there. Deal with it. Scripture says, when you're brought before their court, I will tell you how and what to say. So it's not that we're avoiding that place. We're trying to get our remedy. Our remedy is to use our asset funds. The only reason that judge is attacking you is because if you go out in the street and tell everybody they got 3.5B in their account, you don't have to worry about a traffic ticket anymore. You just go in there and tell that judge, put it on my charge, and then give them your red number. Do you think tomorrow everybody that lined up in court with their Social Security card, hey, judge, put this on my account? And the judge is going to go, there's insanity in the courtroom today. Does the judge for 1 minute believe everybody that came through that door, because you're teaching them at the end of the hallway, does he believe everybody that came through that door is a creditor? No. That doesn't make any damn sense. So the judge is going, we got to weed out the creditors from the debtors. And I bet there's not one damn creditor in the whole mess.
Yeah, that's interesting because there was a situation almost exactly like that. A friend of mine had asked me, she really didn't know what she was doing, and so I gave her a simple remedy of going in, accepting by, Your Honor, I plead guilty to the facts and wish to effect payment immediately. And she was actually talking to people in the gallery, okay? And she was basically telling them what she was going to do. This girl goes up and pleads guilty to the facts, and everyone who followed her did the same thing. The judge had basically realized none of these people are creditors. Somebody said something, and so rather than, because we had another friend who had done it, and she got her fine was like 1/5 what it should be, never went on her record, just totally dissipated. But this girl, as soon as she got to the clerk's window, the fine was right back up at full price, and everyone else who followed her got the fine right back up at full price, and it all went on all their records because it was chaos. The judge expects you all to go into dishonor and to all be not guilty or no contest or something along those lines. As soon as everyone starts pleading guilty to all the traffic charges, he would literally that he could possibly destroy the judicial system in his city and the revenue that they generate from it by being honorable or presuming that these are creditors. So what he did was, okay, guilty, fine, but still treating them as if they were in dishonor. Because he didn't accept, none of them paid the charges there on the spot. So as soon as they left the courtroom, they were in dishonor. Because she said, effect payment immediately. Did she effect payment immediately? No. She walked out and went to the clerk's office. No, she didn't even attempt to effect payment immediately.
You remember the guy that went into the courtroom on the traffic case and told the judge to basically put it on his secured account number? And what happened? Do you remember that?
No, I don't.
Okay, you're the defendant. You're going to come in. I'm the judge. You're going to not plead. You're going to say, I accept, put it on the account. Okay?
Just put it on my account.
There you go. This is what happened in a real court. Okay, we're calling the traffic case today of Nashville versus Mr. Hall. Mr. Hall, you've been charged with speeding today, sir. How do you plead?
Judge, I want to plead guilty, and I want you to just put it on my account. My bond number is 1234567.
Mr. Hall, do you know what you're doing?
I just want to pay it, Your Honor.
So you're willing to accept the plea of guilty, and you want this to be... Are you going to pay this, you said?
Right now, just put it on my account. D123456789. I want to effectuate a payment immediately, Judge.
Prosecutor?
I have no idea what he's talking about, Your Honor. We have no record of an account here. If you'd like, Mr. Hall, you can effect payment with a check, a money order, a credit card, or cash at the clerk's window.
Mr. Prosecutor, I really appreciate your input here today. I think that's probably a wise decision, but something just tells me, and probably my common sense is gone, but I'm going to accept this defendant's offer here today, Your Honor. So what I want you to do, Defendant Hall, is I want you to do the following. I am going to give you 60 minutes, and I want you to return here, and I want you to bring your birth certificate, your driver's license, and your Social Security card with you, and I want you to turn them into the clerk of this court. Do you understand my order, sir?
Yes, sir, I'll go do that.
And if you don't get them here within 60 minutes, sir, there's going to be a warrant out for your arrest. Do you understand what I'm saying?
Yes, sir, I'll be right back.
Okay, sir, you're excused to go.
I made it
Thank
back,
you,
Judge.
Mr. Hall. You are excused, sir. It's nice doing business with you.
Hold on.
1 week later.
The bank.
I
Scene.
need
The bank.
I need a marshal. Marshal Mark. I understand that Mr. Hall is down at the First National Bank. Would you go see if you could round him up and bring him in here, please? So now we've got Marshal Mark bringing Defendant Hall back into the court for an appearance before the judge. Defendant Hall.
Yes, Your Honor.
Would you like to explain to me what you were doing down at the bank today?
I was putting some money in my account, Judge.
I heard by way of the grapevine that you were cashing a check. Is that correct?
I was doing that also, Judge.
Mr. Hall?
Yes, Judge.
At this time, I'm ordering the clerk to return to you your birth certificate, your Social Security card, and your driver's license, and I am finding you guilty of the traffic infraction and ordering you to pay the clerk $125 in fine and $70 in court cost, and you will pay that before you leave here today in Federal Reserve notes, check, money order, whatever it is that you were using at that bank, or else you're going to be taken into custody for contempt. Do you understand me?
Yes, Judge.
You're excused. That was an actual court case. What did the judge do to Defendant Hall? He called his bluff.
He's really giving him the benefit of the doubt. Oh, so you're a sovereign, huh? All right, we'll see. You won't be needing the birth certificate, driver's license, or Social Security card then. You turn those into the clerk.
That's
and
all
then
indicia of the public side.
He went and cashed a check.
What's wrong with cashing a check? Public benefit, using Federal Reserve notes to throw his debt back onto the public. He's not a sovereign on the private side. He wants to be a creditor coming into my court, and he goes out and acts like a debtor all over town.
So here, we're going to have a second witness to him being a debtor, hand him his documents, watch him accept them, and walk away with them, accepting his new status.
Back to being a debtor. You see what kind of games the court can play?
That's a smart judge. That is a really smart judge.
Remember,
and confident.
the judge was advised, don't do this, Your Honor. You can't do that. You know, call me crazy, call me judge, call me anything. I'm going to allow this guy to do it. And he gave the guy enough rope to hang himself.
What should he have done?
What should have who done?
He should not have a bank account.
Why has he got a debtor bank account if he's going to be using asset funds to pay off his debts all over town?
If he's a creditor, he doesn't have debts. And he's not creating public liability by having Federal Reserve notes stored in an account under his name or under the name of his straw man. See, he had just turned in a bunch of documents which in form suggest that he's not the straw man. And yet there's an account open at the bank with this same party's name. See, what he had done is he brought me all these documents confessing to be that person. Right? I said, bring me your birth certificate. Bring me your driver's license. Bring me your Social Security card. Oh, thank you. Now I can find your bank account. And I'm going to have the bank call me as soon as you walk in there.
Well, could he have conditionally accepted that?
He could have.
Instead, I'll bring in...
He could have, but he was anxious because the judge just seemed like he was going along with it. I'm telling you, this judge was tricky.
I know, there has to be...
How do you get a contract? How do you get a contract? Gordon read it. How do you get one? Words, actions, conduct. What words did Defendant Hall say to the judge that got him in trouble? There wasn't any words that got him in trouble that he said to the judge. What actions in court got him in trouble? None. What's this crap about his conduct? He acts like a creditor before me, but he acts like a debtor in the bank. It's different conduct in two different places, demonstrating that the conduct is not in harmony.
So what should he have done when the judge...
He should not have been operating that bank account in any way, shape, and form that the judge would find out about it and link it back to this case.
And be mindful that
he's asking you whether you would have...
There isn't... You're making a presumption that there's one way to handle this. We could sit here for the next hour coming up with ways. Could he not have conditionally accepted upon proof of claim that a sovereign needs such documents as a birth certificate, a Social Security card?
Now, you understand, what did Gordon tell you he put on the back of his checks? What was his wording?
Deposit for credit or exchange for Federal Reserve notes.
Exchange for Federal Reserve notes.
So the judge is assuming that he's endorsing the instrument making him liable. Is his name on there as an endorsement? So when defendant Gordon is back in front of the court and the judge is saying, what were you just doing? Were you cashing a check? I conditionally accept that and proof of claim that there's any signature on there guaranteeing or underwriting the public side of that instrument. What did he do? Just rebut a public benefit. His signature isn't on there as an endorsement, so he's not held liable for a public benefit.
So he doesn't sign.
He doesn't sign his name.
I don't just put that on there. I don't put a signature underneath it. That's all I put on.
There's
I
no
don't put
signature.
those things and then sign it. There's no signature.
So you're not liable on an instrument that your signature does not appear on. So how is he accepting a public benefit? The judge assumed he was.
So the question is, will the bank let you cash checks? No. Will the bank let me deposit for credit or exchange for FRNs? Yes.
Remember, the teller said, would you please sign this? How did Gordon respond?
Why would I want to be liable?
Why would I want to be liable on that instrument? Is that a counteroffer? Yeah. Did she say, well, I'm sorry, you can't deposit this thing then? No, she deposited the instrument. It's a done deal. You see, you got to go by the facts in an individual case, and like Brandon said, there might be 1,000 facts giving you 1,000,000 affirmative defenses with a counterclaim. That's why you got to understand what is the procedure that we're doing and why are people asking these questions. They just want to know whether you're liable or receiving a public benefit. The check got deposited. Was he receiving a public benefit with his signature? No. So how did he violate the prospect of acting in the capacity of a creditor? He was a fiduciary for that account, but his signature did not make him liable on a public instrument. You see?
Did you cash a check? I conditionally accept on proof of claim, and I'm not the fiduciary in that account, carrying out my duties as a fiduciary for the account holder, Gordon Hall. You got only about 375,000 conditional acceptances to do.
See, if liability funds were going into that account, how do we know that Defendant Hall had not filed a 1040V and a 1040 instrument that was showing reporting of income with a voluntary tax on it at 100%? See, if he put in the 1040V, and what is the name of the 1040 where you're filing the reporting of income in a quarter? Yes, estimated return. Okay, let's say Gordon Hall's straw man was depositing a $1,000 check every month. So in the first quarter, he deposited $3,000 worth of checks, which are liability money. Well, the liability money going to straw man is a public benefit because the Federal Reserve notes are military war scrip. Why does the military issue war scrip? So they can track all of the currency in the war zone, in the democracy, because they want to know if there's any terrorists living in this war zone that are operating to defeat the military. Because the military's got to basically secure that war zone. Isn't that what the democracy's doing? So the first thing that happens, they take all the money out of existence because they can't track lawful money. There's no serial numbers on lawful money, gold, silver coins. They don't know who's spending it and where it's going. People could be using the money of the land as terrorism to defeat the military. So they skim all the lawful money out, put it in a warehouse, and what do? They issue war scrip so that they can track all of the payments and all of the finances in order to capture the terrorists. Okay? Now, So Gordon is depositing $1,000 a month. The first quarter he deposits $3,000. War scrip, isn't that taxable because it's a public benefit? What does Gordon do because he doesn't want to do anything which would increase the public debt? Because isn't that what enemies do? And he's not an enemy. So what's he going to do? He's going to file a 1040 ES reporting how much income? $3,000. He's going to fill out the 1040V voucher, and how much tax is he going to pay on the $3,000? $3,000. Why is he paying 100% tax? He doesn't want any benefits. Where is the $3,000 coming from to discharge his 1040V? From his asset account. Now look, didn't the Treasury say, I'll set off your debts dollar for dollar? That's that side of the accounting system. What's your side of the accounting system? I'm going to set off dollar for dollar all of my Federal Reserve note income. If you want them to pay 100% on your debt, you reimburse them 100% on your income. Is your income now a public benefit? No, you've cleaned it up. You just did money laundering. You took all of the privilege of public money benefit and you went back to your private asset account and discharged the benefit dollar for dollar.
10 o'clock, Jake.
You see what we're doing? You're taking yourself out of a public benefit. Now, if defendant Gordon had done that, did the judge know that he did that? No, that's a private transaction. So, Your Honor, I conditionally accept that and proof of claim that there was any public benefit there. And the judges go, what do you mean there's no public benefit there? You cashed a check. Your Honor, I believe there is confidential, commercial information here. Would the court grant an abatement of 30 days to present to the court in chambers evidence of the non-use of public funds? What do you think the judge is going to say? Well, Mr. Gordon, I am really upset with what you did, and at this time, I'm going to give you exactly 30 days, and you better have a record of your evidence in here in chambers in that time showing that you're not accepting any public benefits, or this court is going to hold you in contempt and come down hard on you for the fraud you've been manipulating this court in. What's the judge doing? Saving his face and telling Gordon, you got your 30 days. Please bring me the evidence in chambers. He won. But you've got to understand how to do this. Do you think anybody sitting in that open courtroom would understand what just went on between that judge and Gordon? Not in a heartbeat. Like, what the hell was that about? And they tried to give him back a birth certificate, a social security card, and a driver's license, and he wouldn't take it. What the hell is that idiot doing? You understand how you play this game? Don't you understand? You got to know what's been going on. Who am I? And how do I get my remedy? Because we've told you things today that for many of you, this is brand new information. Doesn't it completely change the whole aspect of how this court case is going to go if you know what you're doing and stick to your guns? Yes.
You referred to yourself as secured party creditor at the beginning. In all the recordings and everything, we heard, I'm here as Milton to help set off and this, that, and the other. But are you referring to yourself as the way you're conducting yourself, or you have UCC-1 filed, or all your bonds and acts of state and all that stuff? Or
how does people learn the truth? Here a little, there a little, through stammering lips and a foreign language.
I would say that those types of documents are great for you to develop your understanding of what being a secured party creditor is. but I don't need those documents.
See, we didn't define any of that today. When we went through the dual trust, we said we were going to cover this briefly.
Yeah, and we could actually start off with that tomorrow, making the distinction of secured party creditor. We could even show you some sample documents that you could file to make record of it. Is it the UCC one that makes you a secured party creditor?
No.
No. It's just a public record of your interest. Do I need the public for my interest? My interest comes from the private side. All of my documents that would, if I even needed documents, because in reality, when I walk into a court and I say, I'm the paramount security interest holder, why do I need a document? Does anyone else here have a claim?
Nobody's going to stand up and argue with you.
Exactly. So why would I need a document?
The prosecutor's going to call you crazy. But he didn't rebut Gordon's or
But he's not going to argue with you. But he won't argue with you.
Let me
Call
answer
your
your question real quick because we're at the end of the time and we'll take it up tomorrow. On that map up there, we had the living man as box 1, 2, and 6. We're going to break up box 6 into 6A and 6B, and you'll see why. Box 1 is called underwriter in commercial language. Box 2 is called secured party creditor. Box 6B, which is what we showed you as box 6, is called principal. Oh, that's an important sounding name. I'd like to be the principal. That means you're the debtor. It's the lowest of the low. Now there's going to be a box 6A. 6A is the authorized representative of the secured party creditor, which is box 2. Box 2 is secured party creditor or surety. But the surety and the underwriter are in the republic. They're in the land of reality. Can any of those people appear below the line? They can't see them. So the creditor and the underwriter need an ambassador to go down and do business in the fiction. The ambassador is the authorized representative of them. So box 6A is the authorized representative. Box 6B is the defendant, debtor, principal, straw man. If you're in Alice in Wonderland, box 1, the living man, is the lion. If you're in Alice in Wonderland, no, Wizard of Oz. If you're in Wizard of Oz, box 2 is the Tin Man, tax identification number man, creditor. If you're in Wizard of Oz, box 6B, Scarecrow. Okay, so when I'm saying I am the authorized representative, I'm box 6A, representing box 2, who's alien and foreign and not here. But box 2 has a claim against the defendant in box 6B. What kind of claim do you have against him? If you filed your UCC 1, who is the creditor? The private trust. That's box 2. Who is the debtor? That's box 6B. That's the principal defendant. Isn't the filing of a UCC 1 filing of a security agreement notice and a lien against the debtor? So doesn't the secured party creditor, the surety in box 2, have a recorded lien against the defendant, debtor, principal in box 6B? Well, if you have a lien on the debtor, defendant in their court, as a secured party creditor, what do you have to do to maintain your priority lien? You got to pay off every other lien claimant. Well, when the state, the city, or them put a traffic ticket citation, isn't that a lien or a claim on the straw man? So what do you have to do to protect your interest in the straw man? You got to go buy out their claim, allowing you to add an additional lien for what you paid that claim for, so that you can put a lien by your box 2 man the creditor, against the Box 6B man. So how did the secured party creditor, Box 2, lose any interest or economic advantage over the defendant? See, what he just did is he paid off the defendant's charge, the $125 speeding ticket and $70 cost. But how did he recoup that? He put an additional lien for $200 against the debtor. So now he's secured to get it back from the debtor. So as a creditor, what are you doing? You're leaning up your debtor to prevent anybody else from getting at him. You're not leaning them. You're leaning your own straw man because you're paying his debts. And in order for you to protect your lien, you got to make sure that the court accepts your payment. Because if the court doesn't accept your payment, you've lost your payment, your security interest, and the court is going after your straw man and stealing his property after you've already paid the court. So why'd you abandon your claim? See, we're not leaning them. We're leaning our own straw man because he caused our trouble by getting into trouble, and now we got to pay his debt and throw a lien on him. Think of your straw man as your kid. He gets into trouble. Who's going to pay to get him out of jail? You. You're the creditor over him, and that kid is going to go to work cleaning his bedroom, cleaning his yard, and washing my car until he pays me, the creditor, back. Are we going?
What was the conclusion with
You
the wife?
sneak out that door, I'll sneak out this door.
What was the conclusion with the wife? Y'all never
With the who?
with the wife. When the judge walked out, y'all had to clean it up for him. What was that conclusion? The wife.
With Dwight? Oh,
I read the thing, but he didn't read it.
we'll leave Gordon here till midnight. He can read you the result. So we'll get it in the morning.
All right.
You guys have a great evening.
Remember.